Breaking news in D.C. with a potentially hugely consequential decision from the D.C. court. I'm serious, hugely consequential, potentially. Judge Tanya Chutkan will allow special counsel Jack Smith to file a 180-page brief laying out why prosecutors believe Donald Trump is not immune for his actions around the 2020 election. Joining us now, MSNBC legal correspondent Lisa Rubin. I have built it up. Explain why it could be so consequential and why Donald Trump's lawyers don't want it to become public.
Well, let's talk about first why it's consequential. In the ordinary course, a party filing a brief in litigation in D.C. federal court has at most 45 pages. Special counsel sought permission to file a 180-page brief where they are going to lay out all of the evidence that they say makes their superseding indictment against former President Trump totally permissible and defensible under the Supreme Court's immunity decision. But that is going to have with it all sorts of citations to what are known as sensitive materials, things like grand jury transcripts, witness interviews, documents we've never seen before. And that, to your second point, is why Donald Trump's folks do not want the public to see this. They say it's totally inappropriate in light of the upcoming election for this to be a public record.
Could you call it kind of like not a mini trial, but would this be Jack Smith laying out more of his evidence, more of his argument, and would it tell the public more of what he says Donald Trump did around the 2020 election?
I think that's what some people are expecting. I put myself in that camp. You'll remember, Katie, after the Supreme Court's decision, a number of folks on our air, including Andrew Weissman, said that the way to handle what the Supreme Court had dumped back in Judge Chutkan's lap was to have something akin to a mini trial. Think about this as a mini trial on the papers alone, meaning we might never see those witnesses take a seat in the courtroom. But yes, Jack Smith is going to take Judge Chutkan on a tour of why they believe, based on the context and circumstances, they can get around the Supreme Court's immunity ruling and hold Donald Trump responsible on all four of the charges that are pending.
So might this become public?
I think it could become public, but it won't become public automatically. Okay. And that's because under an existing order in the case, all sensitive materials have to be treated certain ways. Either the parties have to agree about those materials becoming public, or what they do is they hand the entire filing to Judge Chutkan under seal and also say to her simultaneously, this is the version that we propose the public should see. But at the end of the day, the decision about what we see and when we see it, that belongs to Tanya Chutkan alone.
Alone? There's no way that Trump's team could appeal her decision to the Supreme Court?
I don't think so. I don't think that a decision about sealing is immediately appealable. It's not what we call an interlocutory appeal. But will she allow them to have a say? She could. That's not laid out in this existing order about the treatment of sensitive materials.
Does Trump's team have an argument about the time frame here? It is so close. We're 42 days from an election. If this becomes public, we'll be even closer to an election. DOJ has longstanding policy not to get involved in matters close to an election. This is, I mean, it's DOJ adjacent, I guess you could argue.
Yeah, but even if this is DOJ, I think the DOJ informal policy sometimes gets stretched beyond what it actually intends. DOJ has said it doesn't take active investigative steps either 60 to 90 days before an election. This is a case that is already pending. This is a brief in a public court. This is not like knocking on somebody's door and serving them with a search warrant. It's very different and outside that DOJ policy. We'll have to see.
All right, Lisa Rubin, thank you very much.